Hello, everyone. Welcome to another episode of the Lifetime Legacy Lawyer podcast. I am Thomas Vick, joined by my co-host Seth Wilson. Seth, how's it going today?
Thomas, doing great. How about yourself?
Doing well. Glad that we've seen a little bit of sunshine this week after 10 straight days of cloudy weather here in the central Indiana area. So glad we got through January.
I tell you what, it's always refreshing to get that respite. It seems like it's only for a couple hours in the afternoon usually, but heading into February here, it can get a little gloomy over time. So that was definitely a nice refreshment this week. And, I was kind of thinking about the blog articles that you had out this week, and one of which kind of caught my attention. And it's titled Navigating Advanced Directives in Dementia Care. And the article itself is very helpful, but it made me kind of think about, when do you make your powers of attorney or other types of kind of during life disability documents effective, and how important that decision is, and what are some things we can do to protect ourselves.
Yeah, it is a really important decision on whether, when the power of attorney becomes effective. It's one of the things that we talk about with my clients every single time that we do estate planning documents for them, because so much is impacted by when, the power of attorney takes place or becomes effective. One of the first options you can have with that is upon incapacity, where maybe a doctor or maybe even two doctors have to certify that the individual is no longer able to make health decisions for himself or herself, or financial decisions. And that's kind of a good check and balance, if you will, on the individual's power within the power of attorney, so that somebody isn't with proceeding without authority with that power of attorney. So that's one suggestion. And there's a little bit, I would say that the con of that is you actually have to get the doctor's certification. So that can cause a little bit of a delay, but it's probably a good delay in, I would say, probably most circumstances.
Yeah, it goes back to the classic lawyer answer. It depends, right? And you're looking at various life stations of individuals and family dynamics, and who are the individuals that are being designated as the power of attorney, who might have the rights and responsibilities to exercise. And I think what caught my attention kind of in that idea of the dementia piece is, at some level, individuals can progress and or improve through that process. And so one provider may say, yes, it's time, the power of attorney is now effective, but you may have two doctor reports needed in order for that power of attorney to be accepted. And that's been a scenario that kind of catches people sometimes in a situation where they can't either act as the power of attorney, but the individual themselves can't really act because they have one out of the two doctors who have said, you're not able to manage your own affairs at this point. And so those are the things that kind of tend on the con side of that determination. But most of the time, that is a good protective measure for you as the individual to say, you know what, I'm in charge until two people say I'm not capable of handling my own affairs. So one thing I do talk through with my clients is, if you're in a trusting relationship and you're comfortable with that, you could just make the powers of attorney effective immediately, and then eventually just fire the other person as the power of attorney, I guess, if they didn't do what you wanted to do. But you and I were talking before, what are some other options as to sort of expiring that power of attorney?
Yeah, you could set it as, expiring on a given date. Maybe it is just going to be in effect for 1 year after the date of signing, or maybe 3 years or 5 years. One instance where that might be a good choice is if there's going to be a major surgery and there's going to be a long recovery. Maybe you want 1 or 2 years for an individual to step into your shoes and take take care of your finances and your healthcare decisions for you. But then after that period of time, your attorney in fact no longer is your attorney in fact, and so that, if you still need it, that's not the best situation. But if you are pretty confident that you're going to be fine after that year or two, that would be an instance where you might do a term of years for the power of attorney.
Yeah, I've sometimes suggested that to younger kids as well. So they may be an adult and 18 and heading off to college, and they're signing a power of attorney to mom or dad. And said, well, maybe you don't want to just have that blanket authority for all time. You could set a period of years associated with that. So maybe you say, well, between 18 and 21, I'm okay with them being there, but I want this thing to expire and I'm going to be on my own by 21 or something along those lines. So I think, again, lots of variables play into making that decision, but it's good to know that those options are there. And I always remind folks on the healthcare side, that's a little bit different because you as the individual maintain your authority to communicate your healthcare desires if you can communicate in almost any manner is kind of how we typically set ours up. So a little bit different on that side than the kind of general power of attorney for financial purposes.
Absolutely, because the doctors and the nurses, they're going to be treating you, your person, and you're going to be there for, whatever treatment that is. But with a financial power of attorney, you might be there or you might not be there, and probably you won't be there. And so you're definitely more vulnerable in that situation.
Are there any other concerns someone should have about giving someone their financial power of attorney and making that effective kind of immediately, or either that or on incapacity?
I think you just have to truly trust the person that you're naming as your power of attorney, because depending on how much authority is given in there could be a whole host of things that attorney in fact could do in your name, and they have the authority to do it, and you've got to be comfortable with that. And things go awry when you don't name the right person to fill that position.
Yeah, and by things going awry, I always think of it's the money thing, right? And
Yeah,
so they can have access to your bank accounts, they can spend money on your behalf, and they've been designated with that authority. So the individual or entity relying on that has the right to rely on their agency for you and say, okay, you're authorized to withdraw $100,000 from the bank account or whatever it is. So just be aware that that's part of that consideration as you're thinking about who to name. And I think that's a great reminder, Thomas, of, hey, make sure it's somebody you trust.
yeah, yes.
Well, you had another article that often it kind of highlights some of the questions that we often face in doing an estate plan, and this is, will my home be a gift or a burden to my kids? And a lot of times, I think the article references is that the home is one of the larger assets that we are concerned with when we're dealing with an estate plan. And there are some various tools available, and I think we've talked about them recently, so we won't rehash everything there. But if you think of, for example, a transfer on death deed for a house, what is the legal impact of that to the beneficiary who receives that on someone's death?
The legal impact is that house is that beneficiary's house at death. By operation of law, it just goes directly to that beneficiary's name, and it doesn't go to any other person, no other child. If there are other kids, no other relative, it goes to that beneficiary's legal ownership.
And if there's multiple owners, each owner then has a share, but they own that typically as individual joint tenants, so to speak, or tenants in common, to use the phrase. But they each of you, if there were two of us, then have a right under law to do certain things with that property, right? I may want to sell it and you may not want to sell it,
Right.
but I have a right maybe to force you to sell it now. And so those are some of those things to think about, I think, when you're considering, well, is this gift actually going to be a benefit to my kids, or will it be a burden? And I think that issue helps inform how you want to direct that asset's disposition at death.
Yeah, and also the obligations that go with that property right. You'll have an obligation to pay the property taxes. There may not be much of an income tax, burden on the sale of that house. Just kind of depends on how it shakes out. But whoever's the legal owner of that house is going to have to pay the property taxes. And I can speak from personal experience with my parents. When my grandparents passed away, they couldn't afford the property taxes down in Florida. So we had to, my parents had to sell that property down in Florida because the property taxes were just too much. And so that's an instance where the real estate can become a burden. You don't have the funds to pay for it. And so you got to sell it. And, depending on the market, it may be difficult to sell. And then that turns into a whole nother ball game.
Yeah. So it's always just something to really think about. In theory, it kind of makes sense, what we're doing there, but you really want to ask those questions of how is this going to be received? And one thing I tend to ask my clients is the house sort of the family homestead, and there's sentimental value associated with it that we want to keep it in the family or not? And is it something that maybe you direct that at the appropriate time it be sold and the proceeds divided just as part of that process, rather than making that decision further down the road on your beneficiaries? And I think one of the unforeseen things that we all cannot predict what will happen is what happens when mom and dad are gone, and how does that affect the family dynamics? Because when everybody's here, it sort of works a certain way, and that may have a different reality when mom and dad are gone in terms of the family harmony and dynamics. And so just want to think that through, make sure that you're doing that in as good a way as you can to bring that peace of mind that, hey, this is going to be as simple as we can make it for our beneficiaries.
Yeah, you definitely want to make it simple. And I've had clients that say, I just want to have a specific direction in the trust that says sell the house and distribute it among the beneficiaries. And so you don't even give the trustee a discretion to distribute the property interest in the house. Just flat out sell the house, divide the proceeds and move on.
Yeah.
And that I appreciate when clients tell me that, because that gives a clear direction to the trustee what is supposed to happen.
Yeah. Well, and I don't know about you, but I get a lot of questions from clients on, hey, should I buy some sort of real estate or mortgage fraud protection insurance? Or I'm seeing advertisements around that say, I'm subject to losing my property for property fraud or what have you. And so I was reading in our local Hamilton County report and we'll put the link in the show notes so you can go find this, but there's a statewide effort in Indiana to crack down on mortgage fraud. And part of that includes some property fraud protection. And essentially what it is, or appears to be, I haven't gone in and checked it because I just found this morning, is a service called DocsPop, and that's DoxPop.com, has opened up the ability for individuals to kind of sign in to that service, which is basically a record of most counties' real estate records in Indiana, and I think other jurisdictions as well. But essentially you can set up an alert that monitors their recording system to say, if your name shows up on a newly recorded document, it will send you some sort of alert, I think is what the idea is. And I don't believe there's a cost associated with this, but we use DocsPop in the office quite a bit to look up deeds and ownership and transfer history. So this makes a lot of sense to consider this as just somebody going out and checking your property records from time to time, which you can do for free, on the local county websites most of the time. But this kind of automates that process and seems like a good thing to do to give you some more peace of mind about your real estate and making sure no one's trying to attach a fraudulent title to it.
Yeah, I agree, Seth. It really makes a lot of sense because it seems like, when you move into a new house, everybody in the world knows that you moved into a new house, and you get all of this mail, and, you get these insurance companies that send you mail and say, you've got to buy what they say is mortgage life insurance. And, there's kind of a system that triggers that notice to all of these companies that want your business. And it's sort of the same idea, but you're actually the one that's finding out first, or maybe pretty soon after it happens. There's some kind of document reported in your name, or with regard to your property, you'll get a notice of it, I assume, and you'll be able to investigate and see what's happening. And I think that's a terrific idea that the Hamilton County Reporter reported on, and you can get it through doxpop.com. I think that's great.
Yeah, and again, we'll put the links to that in the show notes so that it's a little bit easier to access and make sure that it is available to you in your particular jurisdiction. And maybe I'll report back on that in future episodes on how that works as I get mine set up. But seems to make a lot of sense because I kind of have a routine of going out and checking the property tax records and making sure that the ownership information is accurate and nobody's put some other type of claim onto the property that's not supposed to be there. And this could take care of that automatically, which is great. So I think it seemed like a really good program, and just one of those sort of just peace of mind things that they're kind of watching things. And if if, like you say, you get on that list, you'll find out pretty quick, and then you can reach out to an attorney and figure out what the options are to get that removed.
Yeah, that's a great feature that DocsPop has. I'm glad that you shared that with me today. I didn't know about that, so it's very good.
Hey, that's, I guess, why we read, huh?
Why we read. That's why we read. Well, I think that about covers it for today. Seth, how can people get in touch with you?
Thomas, we are located here in the heart of Hamilton County in Noblesville, Indiana, and that happens to be our web address as well, noblesvilleattorney.com. How about yourself?
The best way to reach me is by going to vicklaw.org. Vicklaw.org. We're located in Greenwood, Indiana, and be glad to help anybody out if you're in the area. So I think that'll do it for today. Seth, I appreciate it as always, and we'll talk to you next time.
Sounds good, Thomas. See you later.